What does it tell you about a person when they are serving a life sentence for murdering two young men, and their single biggest priority inside prison is getting caught exposing themselves on a monitored video call? What does it tell you when the same woman who had the accelerator pedal of her car pressed to 100% throttle at 92 miles per hour through a business park now has 32 guilty conduct violations inside an Ohio Reformatory and counting? Here is what makes this case different from every other prison conduct story circulating online right now. The Ohio Department of Rehabilitation and Correction unsealed her internal disciplinary records. Not a summary, not a press release. The actual logs. 36 conduct reports. 32 guilty findings. A 60-day video visitation ban for explicit conduct on a supervised call. Another inmate's prescription medication hidden in her cell. Altered state-issued clothing. Unauthorized contraband recovered during multiple unannounced shakedowns. And while all of this has been happening inside her cell block, Dominic Russo's family and Davion Flanagan family have been visiting graves. By the time this video ends, you will understand exactly what those unsealed logs reveal, why her Ohio Supreme Court appeal is permanently finished, and why October of 2037 is looking less like a realistic exit and more like a door that her own behavior has been methodically sealing shut from the inside. Stay until the very end, because the detail about how her entire legal case collapsed, not because of a courtroom argument or a piece of evidence, but because of a single day on a calendar that her own attorneys failed to read correctly, is the most staggering detail in this entire story. Drop a comment right now and tell me where in the world you are watching this from and what time it is over there as you are watching. I read every single one. Hit that like button, share this with someone following this case, and subscribe to Dark Pulse with the notification bell turned all the way on. Now let us get into it. Before the prison logs, before the disciplinary file, before any of the chaos happening inside the Ohio Reformatory for Women, there were two young men whose names deserve to come first. Dominic Russo was 20 years old. Davion Flanagan was 19. Both of them had their entire lives directly in front of them. Families who loved them unconditionally. Friends who looked up to them. Futures that belonged entirely to them. Until the morning of July in 2022, when everything they were ever going to become was taken in a matter of seconds inside a business park in Strongsville, Ohio. Think about what 20 and 19 actually means. Dominic was barely past the point where life had started to feel real, old enough to make his own decisions, young enough that most of the decisions that would define his future were still ahead of him. Davion was the same. Neither of them had made a choice on that morning that put them in that vehicle. They were passengers. They were present. They were gone. Their families did not get a warning. They did not get a chance to say anything that mattered. They got a phone call, and then they got a grief that has not ended and will not end regardless of what happens inside any Ohio correctional facility. Their loss is the actual weight this entire story is built on. Everything that follows, the prison logs, the conduct violations, the revoked privileges, the failed appeal, only matters because of what was taken from those two families on that morning. We do not lose that context for a single moment of this video. Mackenzie Shirilla was the driver of the 2018 Toyota Camry that killed them both. Her defense team presented their case to the court, and they presented it with everything they had. Her lawyers argued that what happened was a horrific and unimaginable accident. They told the court she suffered from an undiagnosed medical condition. They claimed she blacked out completely behind the wheel and retained absolutely no memory of the moments leading up to the crash. That was the explanation her legal team offered for the unexplainable, a young woman who was simply not conscious when the worst thing imaginable happened. The prosecution presented something that could not be explained away by an undiagnosed condition. Police investigators testified that the data recorder inside the vehicle produced a picture the defense had no answer for. The car was traveling at 92 miles per hour through that business park. The accelerator pedal was pressed to 100% throttle for 5 full uninterrupted seconds before the vehicle slammed into a brick building. 5 seconds. That is not a reflexive action. That is not the mechanical result of a body that has lost consciousness. 5 seconds of sustained, deliberate pressure on an accelerator at maximum throttle while a vehicle is moving at 92 miles per hour requires active, continuous engagement. The prosecution went further. The road leading to that building had a curve. Only a conscious, awake, deliberate driver could have navigated that steering wheel to keep the car on the pavement at those extreme speeds before the final impact. The defense's explanation of a complete medical blackout could not account for the sustained steering inputs required to complete that approach at that speed. The judge reviewed everything: the data recorder evidence, the roadway geometry, the velocity, the 5 seconds of full throttle, the medical defense, the prosecution's reconstruction, and delivered her ruling. Mackenzie Shirilla was found guilty of murder. The court stated directly that she had made a conscious choice that day. She was sentenced to 2 concurrent terms of 15 years to life in prison. She was transferred to the Ohio Reformatory for Women to begin serving that sentence. And that is where the second story in this case begins, the one the unsealed disciplinary file tells. Here is something critical to understand before we go into the specific violations, because it reframes everything that follows. In recorded phone calls between Mackenzie and her family, monitored, as every call inside that facility is, and subsequently obtained by media outlets, she speaks about the psychological reality of daily life inside that reformatory in a way that is raw and unguarded. She describes a crushing, sinking boredom, not casual restlessness, something that sounds closer to desperation. In one recorded call, she specifically says she did not even know how to make a book stretch because there was nothing to do. That statement is worth sitting with before we look at a single conduct report. Making a book stretch. When you are facing a life sentence, time becomes the primary weight you carry. Every morning you wake up inside that facility is another morning subtracted from a life you cannot reclaim. The hours do not move the way they move outside. The walls do not change. The rigid routine repeats without variation and without mercy. And for someone who entered that facility as a teenager, someone whose brain was not yet finished developing when that sentence was handed down, the psychological weight of understanding that this is the rest of your life, not a temporary experience, not a phase you will grow through, but the permanent, unchangeable rest of your life, is something that does not land in a single moment. It accumulates. It compounds. It presses down on every hour of every day until the mind starts looking for any source of stimulation, any act of agency, any moment that feels like a choice freely made rather than a routine imposed. That is the psychological context sitting underneath every line in that disciplinary file. It does not excuse what those lines say, but it explains the environment in which they were generated. And understanding that environment is the only way to fully comprehend what 32 guilty conduct findings actually represent. Here is what the raw numbers inside those unsealed conduct reports actually show. The Ohio Department of Rehabilitation and Correction logged 36 total conduct reports against Mackenzie Shirilla in her first years inside the facility. Of those 36 reports, she was formally found guilty of 32 of them. 32 guilty findings for breaking institutional rules. There is a massive, documented disconnect between the image that circulates online, a quiet, misunderstood young woman struggling to survive a harsh environment, and the official state record of an active, ongoing institutional rebellion taking place inside her cell block. Her mother has been publicly advocating for her, painting a picture of a daughter who is simply trying to adapt to an impossible situation. The state's official paperwork tells a different story. What it shows is a consistent, documented pattern of ignoring direct orders from corrections officers, refusing to comply with basic institutional authority, and repeatedly testing the limits of a system that has both the authority and the willingness to remove every privilege she has remaining. The most high-profile violation in that file answers the question of why an inmate serving a life sentence would risk her remaining comforts in the most vivid possible terms. According to the unsealed logs, Mackenzie Shirilla pleaded guilty to a Class II institutional rule violation for explicit conduct on a monitored video call. The official report documents that she exposed herself during a supervised video visitation session while the person on the other end of the call was completely undressed and using adult materials on camera. The prison's response was immediate and documented. A 60-day restriction on all video visitation privileges was imposed and enforced. For someone serving a life sentence, video visitation is not a casual luxury. It is one of the only remaining threads connecting daily existence to the world outside those walls. The primary means through which she maintains any relationship with her mother, with anyone who still picks up when she calls. Losing it for 60 days is not a minor inconvenience. It is a severing of the most important lifeline in her daily life. And every detail of that violation went directly into the permanent file that the parole board will open in October of 2037. The explicit video conduct was not an isolated incident. It was one category in a pattern that the unsealed logs document across multiple distinct areas of institutional life. Corrections officers conducted multiple unannounced cell block searches in her housing unit. These shakedowns are systematic and thorough. Officers enter without warning, search every cell, flip every mattress, empty every personal storage container, and look for anything that violates facility rules. What those searches produce tells you something specific about how she has been operating inside that facility. Officers recovered altered state-issued clothing. In a maximum security reformatory, every inmate wears the same uniform for a reason that is not aesthetic. Uniformity is institutional security. When an inmate modifies their state-issued clothing, corrections officers document it as a direct act of defiance against institutional authority, a physical declaration that the rules applied to every other person in that facility do not apply to this specific individual. Officers also recovered unauthorized arts and crafts materials, glitter, and paint. Some people hear those items and dismiss them as trivial. They are not trivial inside a state correctional facility. They are evidence of an inmate successfully circumventing the strictly controlled commissary system, moving items through channels that corrections staff cannot account for or monitor. That capability matters not because glitter is dangerous, but because an inmate who can successfully conceal unauthorized items has demonstrated both the motivation and the method to conceal items that are significantly more serious. The most dangerous contraband finding was not the clothing or the supplies. Officers found another inmate's prescription medication hidden in her possession. Prescription pills inside a state correctional facility represent one of the most volatile commodities in the entire institutional environment. They are heavily controlled, assigned by medical staff under strict protocols, dispensed individually with documentation, and guarded precisely because their unauthorized movement creates conditions for overdose, coercion, and violent conflict. Finding another inmate's medication in someone's cell does not require complex interpretation. It means unauthorized transfer of controlled pharmaceutical substances occurred inside that housing unit. The logs do not document how the medication came to be there. What they document is that it was there, hidden, in her possession. Beyond the contraband, the unsealed records also document repeated scheduled defiance. Multiple instances are logged where she was documented as out of place during mandatory cell counts, the non-negotiable daily process through which officers physically account for every person inside the facility. A single count discrepancy can lock down an entire reformatory until the numbers reconcile. Being out of place during count does not affect only Mackenzie Shirilla. It affects every other inmate in that building and every corrections officer responsible for maintaining order within it. Additional entries document multiple refusals to follow direct orders regarding housing unit cleanliness and standard facility regulations, refusing to maintain her assigned area, refusing to comply with specific instructions from officers assigned to her unit. When you lay all of these categories alongside each other, the explicit video conduct, the altered clothing, the prescription medication, the unauthorized materials, the count defiance, the direct order refusals, what you are not looking at is a person making isolated, situational mistakes under the pressure of an unfamiliar environment. What you are looking at is a documented, sustained pattern of resistance to institutional authority operating simultaneously across multiple distinct categories of facility life. The corrections officers logging those 36 conduct reports are not writing formal disciplinary actions for entertainment. Every report goes through a formal institutional review process before a finding of guilty is recorded. 32 of those 36 reports produced exactly that finding. If you are still watching at this point, drop a comment with, "I'm still here." Let us see who is truly following this story all the way through. Share this video right now, because what comes next is the section that nobody following Mackenzie Shirilla's case was prepared for. Keep watching. The facility's institutional response to the sustained pattern of violations was direct and practical. Ohio correctional policy requires able-bodied inmates serving life sentences to maintain mandatory work assignments. You do not simply occupy a cell and accumulate conduct violations without consequence to your daily structure. Time must be structured. Labor must be performed. And the structure imposed on that time is calibrated specifically to address the behavioral pattern it is responding to. Mackenzie Shirilla was assigned to the prison kitchen as a mandatory food service worker. For that daily labor, waking before dawn, working in a loud, physically demanding industrial kitchen environment, serving meals to hundreds of fellow inmates, scrubbing and maintaining heavy commercial equipment, she earns up to $24 per month. $24. For an entire month of mandatory pre-dawn kitchen work inside a state correctional facility. At commissary prices inside an Ohio Reformatory, $24 barely covers basic hygiene items, a small supply of instant food, and perhaps enough writing materials to maintain correspondence with the people outside who still write back. The kitchen assignment is not designed to prepare her for a culinary career. It is a behavioral management tool. A structured schedule eliminates the unoccupied hours that appear in the conduct logs immediately preceding some of the documented violations. An exhausted inmate is a less disruptive inmate. The administration is using the physical and temporal demands of mandatory kitchen labor to forcibly interrupt the cycle of boredom-driven institutional rebellion, and they are entirely transparent about that purpose. Whether it will ultimately change the pattern the disciplinary file has documented is a question the file itself will eventually answer. While the conduct violations were accumulating inside the Ohio Reformatory for women, her legal team was working on the only remaining pathway to an earlier release, an appeal to the Ohio Supreme Court arguing that the original trial was flawed and that she deserved a new opportunity in front of a jury. Her defense attorneys constructed the argument. They assembled the paperwork. They prepared the submission, and then they missed the mandatory statutory filing deadline. By one day, the legal requirement in Ohio is that appeals of this nature must be filed within 365 days of the triggering event. Her legal team calculated their deadline and filed what they believed was a timely submission. They were wrong by a single day, and the reason they were wrong by a single day is one of the most staggering administrative failures in recent Ohio appellate history. They failed to account for a leap year. The calendar year in question contained an extra day in February. That extra day pushed the actual legal deadline one day further than her attorneys had calculated. They filed on what they believed was day 365. It was actually day 366. The Ohio Supreme Court's position required no deliberation. The rules governing statutory filing deadlines are not suggestions, and they are not flexible instruments that bend in response to administrative error. The court refused to review the case on its merits. The entire appeal was dismissed on that single procedural basis. Her final legal option for a new trial is permanently closed. Sit with that for a moment, not for Mackenzie Shirilla's sake, but for what it represents about how close the entire conversation about a new trial came to being real. One day, one February day that her attorneys did not account for when they counted the calendar. That is the margin between a live legal argument before the Ohio Supreme Court and a permanent door closing on every appeal she will ever file. Dominic Russo's family does not get an appeal. Davion Flanagan family does not get a procedural technicality that changes their outcome. Those two families have been marking anniversaries and carrying an absence that grows heavier over time rather than lighter. The appeal that could have changed Mackenzie Shirilla's sentence was lost not in a courtroom argument on the merits of the evidence, not because of a judicial ruling on the substance of the trial, but because someone on her legal team did not check a February calendar closely enough. Here is what the convergence of those two parallel stories, the 32 guilty conduct findings and the permanently failed appeal, means for the only remaining event on Mackenzie Shirilla's timeline that carries any real consequence. October of 2037. First parole eligibility. She will walk into a room, sit before a parole board, and ask to be released into a world she has not inhabited as a free person since her teenage years. That board will open two documents and read them sequentially. The first document will be the court record from Strongsville, Ohio in 2022. A vehicle traveling at 92 miles per hour. An accelerator pressed to 100% throttle for 5 continuous seconds. 2 young men dead. A judge who reviewed every piece of evidence presented by both sides and concluded that Mackenzie Shirilla made a conscious choice that morning. The second document will be her institutional conduct file from the Ohio Reformatory for Women. 36 conduct reports. 32 guilty findings. A 60-day video visitation ban for explicit conduct on a supervised call. Prescription medication from another inmate found hidden in her cell. Altered state-issued clothing. Unauthorized contraband recovered across multiple shakedowns. Documented count defiance. Documented order refusals. A mandatory kitchen assignment imposed as a direct behavioral intervention. In Ohio's parole consideration framework, an inmate's institutional conduct record is one of the primary factors in release decisions. The board is not evaluating who you were at the time of your arrest. They are evaluating whether the person sitting across from them has demonstrated, through the documented behavioral record inside the facility, that they are meaningfully different from the person the court found guilty. They are asking whether the daily choices made behind those walls justify the trust required to allow that person to re-enter a society they previously left in ruins. 32 guilty conduct findings do not answer that question in the direction she needs it answered. Her disciplinary record does not disappear. It does not age out of relevance. It does not become less visible with time. Every single finding is permanently placed in her institutional file, and every parole board that ever considers her case will open that file and read every entry from the beginning. The correction system did not build that file. Mackenzie Shirilla built it. One conduct report at a time, starting in the earliest years of a sentence that now has no legal exit mechanism other than the parole board she has been systematically building a case against from the moment she arrived. Dominic Russo was 20 years old. He had his entire life ahead of him. Davion Flanagan was 19. The same. Both of them existed in a world that was supposed to keep going. Jobs they would have worked, relationships they would have built, ordinary mornings they would have moved through without any documentation, without any headline, without any record, because they would have been simply living. Two young men generating the unremarkable, irreplaceable texture of a life being lived fully and freely. They do not get October of 2037. They do not get a parole hearing. They do not get the chance to explain themselves to a board and ask to go home. They do not get the opportunity to demonstrate that they are different people from who they were, because they never got the years that would have allowed them to become different people. Their families are marking anniversaries in the only way available to them, by returning to the fact of the loss again and again, year after year, with a grief that does not reduce in weight and does not become easier to carry simply because time has passed. And while that has been happening, the person the court found responsible for their deaths has been generating a conduct file inside an Ohio correctional facility that reads, entry by entry, like a sustained argument against her own future. The cameras from the courtroom are long gone. The trial coverage moved to other cases years ago. The legal appeals have been permanently exhausted. What remains now is a maximum security reformatory, a mandatory kitchen assignment paying $24 per month, a permanent disciplinary record that will follow her into every parole consideration for the rest of her life, and a hearing date in October of 2037 that she has been actively undermining since the first year of her sentence. The reality of her situation is not abstract or theoretical. It is documented. It is unsealed. It is the official record of what the state of Ohio has formally observed about who Mackenzie Shirilla has chosen to be inside that facility since she arrived. Dominic Russo and Davion Flanagan deserved better than the morning of July 2022. And the parole board in 2037 will read every page of every document that records what the person responsible for that morning did with the years that followed. Drop a comment below right now and tell me where in the world you are watching from and what time it is over there. Hit that like button. Share this with someone who has been following this case. And subscribe to Dark Pulse with the notification bell turned all the way on. Because when the 2037 parole hearing date approaches, Dark Pulse will be here with the full breakdown of what that file looks like by then. For Dominic Russo, for Davion Flanagan, for the families who do not get a parole hearing and will never get a second chance at the lives that were taken from them. This case is not over, and neither are we.